tenants to complete an application before a lease even comes into play. So can a landlord require a tenant to fill out an application and provide certain background information and consent to a credit check?
Absolutely. And landlords in New York City, at least, do that routinely. And if the credit check is okay, and also a court check, if that's okay, then the tenant would be accepted. The court check is actually a check on whether the tenant has been involved in any landlord-tenant proceedings in the courthouses, and it's called a blacklist. And if a tenant has been involved in such proceedings, landlord might just reject that tenant outright. Also, the application is very important because the lease may provide, say in a rider, that if tenant misrepresented any facts on the application form, that it's grounds for eviction of the tenant.
Now, there are a lot of reasons a landlord cannot discriminate or disqualify or refuse to rent to a tenant, and we'll come to those in a minute. But a landlord is allowed to refuse to rent, especially a market rate apartment, if they feel the tenant's income is insufficient?
Absolutely.
So it's like qualifying for a loan.
Right, and a broker would be best, in the best position to tell you what those financial ramifications are. It used to be 1/3 of your income should be for rent and no more. Now it might be approaching more like 1/2.
Oh, so it's gone up.
Yes,
and
a broker would be in a better position to guide a tenant on that issue.
But a landlord could ask for pay stubs. They could ask for verification from the employer. They could ask for tax returns.
Absolutely.
So it's almost like you're buying something or qualifying for a mortgage. The landlord can do all that due diligence.
Yes, absolutely.
But a landlord cannot discriminate against a person because they don't like them or because of ethnicity or sexual orientation or having a family or anything like that?
Well, if a landlord doesn't like a tenant, a landlord could send a tenant away, but there are prohibited forms of discrimination, such as, discrimination on the basis of race, creed, national origin, sex, marital status,
so they could discriminate. They could discriminate because of personality, but not one of those other protected areas.
Right, and in New York City there are additional protected areas, which are gender, sexual orientation, lawful occupation, no discrimination against attorneys, immigration status, lawful source of income. Can't discriminate against somebody because they get money from the federal Section 8 program. You can't discriminate in New York City against recovering alcoholics or HIV-positive persons. However, and also, most importantly, a landlord cannot discriminate against a prospective tenant if the tenant has a child or children, unless it's a federally subsidized or insured senior citizen housing complex.
So you really can't ask questions on an application about these things, but you could conduct an interview, but you would not be allowed to ask questions about those areas.
Absolutely not.
And you could have an investigator do a background check or ask for character references, but you could not touch on any of those areas.
Absolutely not on those areas.
Okay, and what are some other things that might be included in a lease?
Well,
or perhaps different notice provisions.
Yes, a notice provision is very important. How does the tenant give notice to the landlord? How should the landlord give notice to the tenant? By certified mail, by email, where the rent payment should be sent and delivered, how it should be made, a set of rules that tenant must obey. Something called the default clause would be in a lease, giving a tenant a certain number of days to cure or correct the default, and a certain number of days until the lease would be terminated. It would provide who, as we discussed, who can occupy the premises. It might provide require a tenant to obtain apartment insurance naming landlord as insured as well as tenant. It would, it might definitely should provide an access clause making the tenant responsible for allowing the landlord into the premises in the event any repairs need to be made.
Would the landlord also have to be allowed in just to inspect things?
Absolutely. Leases do routinely provide that landlord could come in for an inspection, and maybe 30 days before the termination of the lease, that new prospective tenants could be allowed to enter and inspect. If the landlord is looking to obtain a new mortgage on the property, tenants have to give access to the bankers who come to the premises, etc.
And it would generally be on notice unless there's some type of emergency.
Right. It would be, in New York City, it's 8 days notice, but in an emergency, that it's possible that no notice whatsoever would be given, and that would be okay in case of a fire, a leak, or smoke condition or something like that.
And the leases usually contain a waiver of a right to trial by jury?
Yes, a right to trial by jury in a landlord-tenant dispute, but it is not legal to waive a right to trial by jury in the event tenant slips and falls and hurts him or herself at the premises. That is a different kind of case, and tenant cannot waive the right to trial by jury.
And is there also some provision where a tenant would be asked to waive counterclaims or defenses in a landlord-related litigation?
Absolutely. That's often included in a lease. For instance, if a tenant is being sued for non-payment of rent, the tenant cannot assert an unrelated counterclaim, such as your sidewalk was broken and I tripped and fell and hurt myself. That would be an unrelated counterclaim to the non-payment proceeding.
And what are some issues any other clauses that you want to comment on, or any other clauses that might be illegal in a lease?
Oh, there are many clauses that I find in form leases that are absolutely illegal. There are clauses that say a landlord is not liable for injuries that the tenant may suffer if landlord negligently maintains its property. A lease, and that's illegal. A lease might provide that an apartment can only be occupied by tenant, and as we discussed, that's illegal. A lease might say tenant is not allowed to sublet, but this prohibition is not enforceable if the building has 4 or more apartments. A lease might provide that you're not allowed to have pets, but as we discussed, there are exceptions to that.
And the subletting, would the landlord have to approve the subtenant?
Yes, the tenant would have to make, under the real property law, the tenant has to make a request providing 6 different types of information. The name of the proposed subtenant, et cetera, et cetera. A tenant has to refer to the real property law, and it had best, retain an attorney to make a proper request.
And also, we talked earlier about qualifying credit income-wise. A tenant, if the landlord allows them, might be able to have someone be a guarantor of the financial terms of the lease?
And that often happens with college students, that somebody might come in, a parent might come in and be a guarantor.
But is the landlord under any obligation to accept someone else as a guarantor?
A landlord can accept any adult who's standing up for the tenant to be a guarantor.
Okay. And by the same token, if someone sublets a lease, does it properly, the tenant is still financially liable for the terms of the lease?
Absolutely. Thank you for saying that. Yes, the tenant, during the sublet term, the tenant remains financially liable to landlord, and the subtenant is responsible to the tenant.
Okay. We are running low on time, but I just want to one thing a lease also usually includes is quiet enjoyment of the apartment. What does that mean?
Quiet enjoyment of the apartment means that there should not be any third party who bursts into the apartment and says, "This is mine." A landlord must protect against that. And also, there's a warranty of habitability written into every lease.
Basic living conditions and safe conditions.
Right. It's fit for human habitation.
Okay. And now what if a tenant wants out of the lease, although it's, let's say, for 1 or 2 years? What can you as the attorney do for the tenant? What can the tenant do to try to legally get out of the lease or end it soon, prematurely?
Well, there's 3 situations where a tenant is allowed to end a lease prematurely. A military person who is going on active duty can end a lease prematurely. A 62-year-old person or older who wants to go live in a child's home or an assisted living facility or nursing home. And there was one other situation. Victims of domestic violence could end a lease early by giving a 10-day notice if they're in danger and need to end the lease.
Okay. And otherwise, the tenant can negotiate with the landlord and maybe they can reach some accommodation.
Right. Perhaps. I have upon occasions asked landlords to give a release to my client who's a tenant in exchange for a sum of money which is somewhat less than what would be due under the lease. Right,
and then they can always rent it out again and remain and achieve wholeness. Listen, also in terms of right to renew, let's say it's a 1-year lease, does the tenant have a right to automatic renewal?
Under the rent stabilization law, yes, absolutely, but under, in market conditions, only if it's written into the lease, very specifically, you're allowed to renew for 1 additional term at a specific rent.
But you can negotiate it, but it may not be automatic.
It may not be automatic.
Linda, I wish we had some more time, but you've given out a lot of helpful information. I want to remind our listeners what you've heard is presented as information only. You should get legal advice for your own situation from an attorney, your personal attorney who's been informed of all the specifics of your situation. And Linda Resnowicki has an office in Lower Manhattan, and she also has a website, landlordtenantlaw.net. You're listening to Law You Should Know here on 90.3 WHPC, the voice of Ness Community College in Garden City, Long Island, New York, and over the internet at ncc.edu/WHPC. Please join us next week at this same time for another program on Law You Should Know.